Good people, good people, good people. What's going on? It's been a little minute since I came and I hollered at you guys. But today I have a really very interesting reading for you. And this reading is going to be about, or the topic of will be what kind of court you're in. And I was doing some research myself on my own time. And what I come to find out was that they bring the people into what's called a tax court. So that's the type of court that people are being brought into. So I said, let me do some research. And I went on to Wikipedia and just looked up United States Tax Court. And come to find out they don't really hide much from us. So I read it, and I think it's very interesting. And let's see what it says. The United States Tax Court is a federal trial court of record established by Congress under Article 1 of the United States Constitution, Section 8, of which provides in part that the Congress has the power to constitute tribunals inferior to the Supreme Court. The tax court specializes in adjudicating disputes over federal income tax, generally prior to the time at which formal tax assessments are made by the Internal Revenue Service, through which taxpayers may choose to litigate tax matters in a variety of legal settings outside of bankruptcy. The tax court is the only forum in which taxpayers may do so without having first paid the disputed tax in full. Parties who contest the imposition of a tax may also bring an action in any United States District Court or in the United States Court of Federal Claims. However, these venues require that the tax first be paid and that the party then file suit to recover the contested amount paid. The full payment rule of Florida versus United States. The history of the tax court is the first incarnation of the tax court was the U.S. Board of Tax Appeals, established by Congress in the Revenue Act of 1924, also known as the Mellon Tax Bill, in order to address the increasing complexity of tax-related litigation. Those serving on the board were simply designated as members. Back to the top. History. The first incarnation of the tax court was the U.S. Board of Tax Appeals, established by Congress in the Revenue Act of 1924, also known as the Mellon Tax Bill, in order to address the increasing complexity of tax-related litigation. Those serving on the board were simply designated as members. The members of the board were empowered to select on a biennial basis one of their members as chairman. In July 1924, President Calvin Coolidge announced the appointment of the first 12 appointees, of which 7 were appointed from private life and 5 from the Bureau of Internal Revenue. Additional members were appointed in the fall, and the board, when fully constituted, originally had 16 members. With Charles D. Hamill serving as chairman, the board was initially established as an independent agency in the executive branch of the government. It was housed in the Internal Revenue Service building in the Federal Triangle. The first session of the Board of Tax Appeals spanned July 16, 1924 to May 31st, 1925. In 1929, the United States Supreme Court ruled that the United States Supreme Court ruled that the Board of Tax Appeals was not a court, but was instead an executive or administrative board. Sound familiar? Upon the decision of which the parties are given an opportunity to base a petition for review to the courts after the administrative inquiry of the board has been had and decided. In 1942, Congress passed the Revenue Act of 1942, renaming the board as the Tax Court of the United States. With this change, the members became judges, and the chairman became the presiding judge. By 1956, overcrowding and the desire to separate judicial and executive powers led to initial attempts to relocate the court. In 1962, Secretary of the Treasury Douglas Dillon appealed to the General Services Administration, sound familiar, to incorporate funds for the design of a new building in its upcoming budget. The GSA allocated $450,000 and commissioned renowned architect Victor A. Lundy, who produced a design that was approved in 1966. However, funding constraints brought on by the Vietnam War delayed the start of construction until 1972. The tax court was again renamed to its to its current formal designation in the Tax Reform Act of 1969, changing it from an historically administrative court to a full judicial court. The completed United States Tax Court building was dedicated on November 22, 1974, the 50th anniversary of the Revenue Act that created the court. In 1991, the U.S. Supreme Court in Freytag versus Commissioner stated that the current United States Tax Court is an Article I legislative court that exercises a portion of the judicial power of the United States. The court explained the tax court exercises judicial power to the exclusion of any other function, and that it exercises its judicial power in much the same way as the federal district courts exercise theirs. This exclusively judicial role distinguishes it from other non-Article III tribunals that perform multiple functions. And the Article III tribunal will be the judicial branch of the government of the United States. Article I being a legislative branch. As we continue, thus, Freytag concluded that the tax court exercises judicial rather than executive, legislative, or administrative power. The tax court remains independent of the executive and legislative branches, in the sense that its decisions are not subject to appellate review by Congress, the President, or for that matter, Article III district courts. The President, however, may remove tax court judges after notice and opportunity for public hearing for inefficiency, neglect of duty, or malfeasance in office. Justice Scalia, one of my favorite justices, rest his soul, penned a separate concurrent for 4 justices in Freytag. These justices dissented as to the court majority rationale. They would have characterized the tax court's power as executive rather than judicial. Scalia said that to him. It seemed entirely obvious that the tax court, like the Internal Revenue Service, the FCC, and the NLRB, exercises executive power. Notwithstanding Scalia's sharp dissents in landmark separation of power cases, such as Mistretta versus United States and Morrison versus Olson, Scalia apparently described Freytag as the single worst opinion of his incumbency on the United States Supreme Court. Although the 2008 United States Government Directory of Executive and Legislative Appointed Officers, the Plum Book, categorized the tax court as part of the legislative branch, the 2012 revised version removed the tax court and listed it under neither the legislative nor the executive branches. And an amendment to the Internal Revenue Code of 1986, enacted in late 2015, the U.S. Tax Court is not an agency of and shall be independent of the executive branch of the government. However, Section 7443F of the Code still provides that a tax court judge may be removed by the President for inefficiency, neglect of duty, or malfeasance in office. Jurisdiction of the tax court. The tax court provides a judicial forum in which affected persons can dispute tax deficiencies determined by the Commissioner of Internal Revenue prior to payment of the disputed amounts. The jurisdiction of the tax court includes, but is not limited to, the authority to hear 1. Tax disputes concerning notices of deficiency, 2. Notices of transferee liability, 3. Certain types of declaratory judgment, 4. Readjustment and adjustment of partnership terms, 5. Review of the failure to abate interest, 6. Administrative costs, 7. Worker classification, 8. Relief from joint and several liability on a joint return, and 9. Review of certain collection actions. Congress amended the Internal Revenue Code, now codified in Internal Revenue Code Section 7482, providing that decisions of the tax court may be reviewed by the applicable geographical United States Court of Appeals, other than the Court of Appeals for the Federal Circuit. See Article 1 and Article 3 tribunals. Small tax cases are conducted under Internal Revenue Code Section 7463 and generally involve amounts in controversy of $50,000 or less for any one tax year. The small tax case procedure is available at the option of the taxpayer. These cases are neither appealable nor presidential. At times, there have been efforts in Congress and the tax bar to create a single national court of appeals for tax cases or make tax court decisions appealable to a single existing court of appeals to maintain uniformity in the application of the nation's tax laws. The very reason underlying the creation of the tax court and the grant of national jurisdiction to the tax court, but efforts to avoid hometown results or inconsistent results due to a lack of expertise have failed. An important reason for the movement to create a single national court of appeals for tax cases is that the United States Tax Court does not have exclusive jurisdiction over tax cases. In addition to the tax court, federal tax matters can be heard and decided in 3 other courts: U.S. District Courts, the Court of Federal Claims, and the Bankruptcy Court. In the first 2 instances, the taxpayer bringing the claim generally must have first paid the deficiency determined by the IRS. For the Bankruptcy Court, the tax matter must arise as an issue in a bankruptcy proceeding. Bankruptcy Court appeals are initially to the U.S. District Court. Appeals beyond the U.S. District Court and the Court of Federal Claims follow the same path as those from the U.S. Tax Court as described above. With this number of courts involved in making legal determinations on federal tax matters, some observers expressed concern that the tax laws can be interpreted differently for like cases. Representation of parties. The Chief Counsel of the Internal Revenue Service or his delegate represents the executive branch in the tax court. The tax court permits persons who are not attorneys to be admitted to practice to represent taxpayers by applying for admission and passing an examination administered by the court. Attorneys who provide evidence of membership and good standing in the state bar of the D.C. bar can be admitted to the bar or can be admitted to the bar of the court without sitting for the tax court examination. Tax court practice is highly specialized, and most practitioners are licensed attorneys who specialize in tax controversies. Genesis of a tax court dispute. Many tax court cases involve disputes over federal income tax and penalties, often after an examination by the Internal Revenue Service of a taxpayer's return. After issuance of a series of preliminary written notices and a lack of agreement between the taxpayer and the IRS formally determines the amount of the deficiency and issues a formal notice called a statutory notice of deficiency or 90-day letter. In this context, the term deficiency is a legal term of art and is not necessarily equal to the amount of unpaid tax, although it usually is. This deficiency is generally the excess of the amount the IRS contends is the correct tax over the amount the taxpayer showed on the return, in both cases without regard to how much has actually been paid. Upon issuance of a statutory notice of deficiency after IRS determination of the tax amount, but before the formal IRS assessment of the tax, the taxpayer generally has 90 days to file a tax court petition for redetermination of the deficiency. If no petition is timely filed, the IRS may then statutorily assess the tax. To assess the tax in this sense means to administratively and formally record the tax on the books of the United States Department of the Treasury. This formal statutory assessment is a critical act, as the statutory tax lien that later arises is effective retroactively to the date of the assessment and encumbers all property and rights to property of the taxpayer. Life cycle of a tax court case. Because of the negative legal consequences ensuing with respect to a statutory assessment, especially the tax lien and the Florida requirement that the taxpayer otherwise pay the full disputed amount and sue for refund, a taxpayer is often well advised to file a tax court petition in a timely manner. The rule in the tax court is that the taxpayer sues the Commissioner of Internal Revenue, with the taxpayer as petitioner and the commissioner as respondent. This rule is an example of an exception to the general rule that the proper party defendant in a tax case filed by a taxpayer against the federal government is the United States of America. In the tax court, the commissioner is not named personally. The Secretary of the Treasury, the Department of the Treasury, and the Internal Revenue Service are not proper parties. The petition must be timely filed within the allowable time. The court cannot extend the time for filing, which is set by statute. A 60-day filing fee must be paid when the petition is filed. Once the petition is filed, payment of the underlying tax ordinarily is postponed until the case has been decided. In certain tax disputes involving $50,000 or less, taxpayers may elect to have the case conducted under the court's simplified small tax case procedure. Trials in small tax cases generally are less formal and result in a speedier disposition. However, decisions entered pursuant to small tax case procedures are not appealable and are not precedential. Cases are calendared for trial as soon as practicable, on a first in, first out basis after the case becomes an issue. When that case is calendared, the parties are notified by the court of the date, time, and place of trial. Trials are conducted before one judge without a jury, and taxpayers are permitted to represent themselves if they desire. However, the vast majority of cases are settled by mutual agreement without the necessity of a trial. However, if a trial is conducted in due course, a report is ordinarily issued by the presiding judge, setting forth findings of fact and opinion. The case is then closed in accordance with the judge's opinion by entry of a decision. Appellate review. Either the petitioner, the taxpayer, or the respondent, the Commissioner of Internal Revenue Service, may take an appeal from an adverse decision of the tax court to the appropriate United States Court of Appeals. In the case of an appeal by the taxpayer, a bond is normally required in order to avoid enforcement action during the pendency of the appeal. Instead of taking an appeal, the Internal Revenue Service may issue an action or decision indicating the Commissioner's non-acquiescence in the decision, meaning that the Commissioner will not follow the decision in subsequent cases. In such cases, the Commissioner hopes for the opportunity to litigate the matter in another circuit where he will have a better chance of obtaining reversal on appeal. Judges. The tax court is composed of 19 judges appointed by the President and confirmed by the Senate. Former judges whose terms have ended may become senior judges, able to return and assist the court by hearing cases while serving on recall. In addition, the court is assisted by a number of special trial judges who are employees of the court, appointed by the chief judge of the tax court rather than by the President. Special trial judges serve a function similar to that of United States magistrate judges of the district courts and may hear cases regarding alleged deficiencies or overpayments of up to $50,000. It's kind of weird to say that they serve a function similar to that of United States magistrate judges. I guess that's because that's who the magistrates are, a tax judge, here in the tax case. Reappointment when requested by a tax court judge is generally formal, regardless of the political party of the appointed president and the political party of the reappointing sitting president. Each active judge appointed by the president has 2 law clerks. Attorney advisors and each senior judge and special trial judge has 1 law clerk. President George W. Bush was heavily criticized by the United States Congress, the tax bar, and others when he indicated that he likely would not or might not reappoint tax court judges whose terms were expiring, even though the first judge whose reappointment President postponed question was Judge John O. Colvin, was appointed by President Ronald Reagan. President Bill Clinton also was criticized for not acting timely to reappoint tax court judges, having allowed one sitting judge's term to expire, thus requiring the tax court to elect a new chief judge. Additionally, several tax court judges had to wait more than a year, sometimes more than 2 years, to be reappointed during the Clinton presidency. This takes me to a real interesting video that I came across on. Shout out to Yusuf El, on Yusuf El's channel about old cases and tax cases. And it's a little short one. I'm going to go over to SBC University, high frequency radio, and highlight Yusuf El. He does great presentations. And he's one of the people that I learned some extensive knowledge from. Shout out to Shah as well. Go check him out as well. The Deprogram Enlightener. Go check the boy out. Really good, valuable information. But this is Gene Keaton on the Brother Yusuf El's page. Let's hear what Gene Keaton has to say about tax court.
Okay, we're going to go back to the original issue discount. And I'm going to go over where all this stems from. This all stems from HJR 192. And here's the phrase: shall be discharged upon payment dollar for dollar when any coin of currency which at the time of payment is legal tender for all public and private debt. What was legal tender for all debt, public and private, in 1933? Gold was. The government confiscated all your gold. They sent it to China, so they had to give you, that was payment or discharge upon presentment. They discharged all of your debt. Future. This is future. You can't take somebody's money away and not give them compensation.
Compensation. Contract civil law. When two persons are equally indebted to each other, there takes place a compensation between them, which extinguishes both debts. Compensation is, therefore, a reciprocal liberation between two persons who are creditors and debtors to each other, which liberation takes place instead of payment and prevents a circuity. Sense 2. Compensation takes place, of course, by the mere operation of law. Even unknown to the debtors, the two debts are reciprocally extinguished as soon as they exist simultaneously, to the amount of their respective sums. Compensation takes place only between two debts, having equally for their object a sum of money or a certainty of consumable things of one and the same kind, and which are equally liquidated and demandable. Compensation takes place, whatever be the cause of either the debts, except in case, first, of a demand of restitution of a thing of which the owner has been unjustly deprived, second, of a demand of restitution of a deposit and a loan for use, third, of a debt which has for its cause ailments declared not liable to seizure. Compensation is of three kinds: one, legal or by operation of law; two, compensation by way of exception; and three, by reconvention. Compensation very nearly resembles the set off of the common law. The principal difference is this: that a set off to have any effect must be pleaded, whereas compensation is effectual without any such plea. Only the balance is a debt. Bouvier's 1856.
So they compensated you by prepaying all of your debt, dollar for dollar. This has been going on since 1933, and nobody understands it because they keep trying to pay debts that are prepaid because people don't understand the OID process. So I'm going to go over this. I keep going over this because this is the crux of everybody's problem. I don't care if you're in a criminal case, you're in a civil case, it's a tax case. And if you don't understand what a tax is, you don't understand what's going on. Everybody I talk to goes, oh yeah, I understand what a tax is. And I start asking them questions and they can't answer.
Tax. A monetary charge imposed by the government on persons, entities, transactions, or property to yield public revenue. Most broadly, the term embraces all governmental impositions on the person, property, privileges, occupations, and enjoyment of the people, and includes duties, imposts, and excises. Although a tax is often thought of as being pecuniary in nature, it is not necessarily payable in money. Taxes are enforced proportional contributions from persons and property levied by the state by virtue of its sovereignty for the support of government and for all public needs. This definition of taxes, often referred to as Cooley's definition, has been quoted and endorsed or approved expressly or otherwise by many different courts. While this definition of taxes characterizes them as contributions, other definitions refer to them as impost, duty or impost, charges, burdens, or exactions, but these variations in phraseology are of no practical importance. Black's Law Dictionary, 8th edition.
That means they don't understand what taxes are. It's not a tax until you do an assessment. You have to assess the tax. Why do you have to assess the tax? Because you own the credit that the government chooses. You are the owner of the credit. You are the creditor in fact. That's why the government, every time they use your credit, has to give you an OID identifying you as the payor and themselves as the recipient of the fund. Everybody understand that? You can't get much simpler than that. Go read the OID publication. Go read publication 1212. I haven't had one person in the patriot community that's ever read publication 1212. I'm going to take you in there and explain it to you so that everybody can understand it. You got to understand that your law, everybody's looking for a remedy. You can't get a remedy until you understand what's going on. That's why God invented me. I'm going to explain to you. I've been studying this stuff for 50 years. And I'm going to prove to you right now. Go to page 6. Nobody has read this publication. Nobody. Nobody. Nobody reads this publication. This tells you what is going on. There's one paragraph in this document that gives you the whole key to the whole redemption process. Now I'm going to show you what it is. And nobody knows this even exists. Download publication 1212 off the IRS website. Follow along with me. You'll learn what's going on. Nominee. This is what's going on. What are they doing? They're doing a nominee for the true owner, which is you. If you are the holder of an OID, original issue discount debt instrument, and you receive a Form 1099 OID that shows your taxpayer identification number and includes amounts belonging to another person, you are considered a nominee. Well, what are those amounts belonging to another person? That's the amount of the bills that all of these corporations are sending you every month for the use of your credit. And they're reporting it on a tax statement. They're using your credit. And they're doing it as a nominee for you because they're using your credit. You must file another Form 1099 OID for each actual owner. You are the owner. You are the payor on the 1099 OID because they're using your credit. And they send you a bill to notice you that that's the amount of your credit that they are using. Now, that doesn't become a tax until you assess it. And the way that you assess it is you have to file a 1040 tax form and a 1099 OID and a 1096 and a 1040B.
With Google Workspace, you can get any job done on your phone. From giving feedback, to attending meetings, to signing contracts. That's working from anywhere.
And you do it. Pay to the orderer. Who do you pay it to? You pay it to the U.S. Department of Treasury. Why? Because the U.S. Department of Treasury is handling the bookkeeping. And unless you report it as a return or a tax, they can't do the bookkeeping on it. That's why the Treasury's books are all screwed up. Their payables and their receivables are out of balance. Payables are what they owe to you, and they can't pay you because you haven't filed the proper paperwork to get the refund on the credit that you're giving away to everybody. You can't get much simpler than that.
So after 3 years, somebody else comes in and grabs that.
Yeah, so what they're doing, because it's abandoned property, because you never claimed it, so they do it. They do this nominee. They do it in your name. And they use your taxpayer identification number. And they do a 1099A showing it as abandoned property because you never claimed it. It's like taking a $100,000 suitcase full of $100,000 bills and throwing it down on the sidewalk. Whoever claims it owns it. If you think this is what's going on, you're going to be in for a rude awakening. It's exactly what they're doing. If you are a holder of an OID instrument that shows your taxpayer, that's why you ask them for their taxpayer identification number. Because that way you can identify them as the recipient of the fund. You can't do that until you get their taxpayer identification number. that shows your taxpayer identification number and includes amounts belonging to another person, you are considered a nominee. Well, what are the amounts belonging to another person? That's the amount of the credit that they're using. That's the amount of the credit, and that's represented by the tax, by you assessing the tax. When you assess the tax, it becomes a return or a tax issue, or a tax matter. Now, if you show them as a recipient of the funds, then the IRS can issue you a refund. But this is what they're doing. And if you don't do this, then you've abandoned the funds. So they give them away to somebody else. If you think this isn't what's going on, I've talked to Alton Brown.
Yeah, that's Gene Keaton dropping it. That's Gene Keaton dropping it, folks. That's Gene Keaton dropping it, folks. I put my camera, my light back on. I turned my light off. I want it to be, the guys seeing me in a lighter setting. I don't tip the hat on them. You know what I mean? I got my big gold coin behind me. But yeah, folks, peace and blessings. And I'll leave you with some dope music.
Word up, New York City. Yo, Rob, why don't you talk to the people for a minute? Tell them why we're here. All right. That old man. Yeah. Once upon a rhyme with a scenery set, you see stress. Streets are matter of life and death, no regret. Life's the test, strife with special effects. Neighborhoods full of reps, cities of projects where the young cadets get stripes from the best. Comrades neglect to be the next to finesse, collect debt and select best with death threat. Object, cheddar, better your total net. Trends to set, red, stress the outlet. Friends get wet, trying to make ends connect. Avenues to check, boulevard to sweat. Smell a gun smoke, small common as cigarettes. We got pits for rest, we got clicks for wreck. We got giants and jets, the Knicks, Yanks, and Mets. We like